Well, everyone, I'd like to officially welcome you to the American Foreign Service Association headquarters on this beautiful day. Thank you for being here. My name is Ian Houston. I'm the Executive Director of AFSA. So it's a real pleasure to have you here. Many of you will be members of AFSA, some not, but we nevertheless appreciate your participation in this event and support of AFSA as we move forward with a variety of programs that we design both for our members and the Foreign Service community and families as we try to be a thoughtful resource and a compassionate organization to address the many needs that are out there amongst our members and within the Foreign Service. So it is my pleasure to welcome all of you here to this panel discussion on divorce in the Foreign Service. This is the 6th installment of a series that AFSA has put together on federal benefits issues. So we're proud of a program now that has quite a history. All of these programs we record and place on our YouTube channel, so you may access them, and will eventually be quite a resource and library online for members. This being the 6th installment, we do record it, and I just remind the panelists that we do that. For the Q&A period, which we will have, also a reminder to the audience to speak loudly, not so much for the folks in this room, but that we properly pick it up on the camera as we record it. So we hope this event really will be an opportunity for you to become a resource on this issue for colleagues at your post or in your bureau who may go through such a life change and a challenge. Or in the event that you yourself may be affected. It is a pleasure for me to welcome our guests, principally Susan Frost, who is the Director of the Family Liaison Office. Susan, thank you for being here. Susan will serve as our moderator today. Among the panel guests are my close and good friend Daniel Hirsch, who is a management officer and former AFSA vice president at State Department for 4 years, who served very well on our governing board. Thank you for being here, Daniel. And we also have work-life specialist Elizabeth Royal, who's here with us today. Elizabeth, thank you for being here. Jacqueline Lon. Jacqueline is a Chief Policy Advisor of the Office of Retirement. And Sharon Savanti, yes, who's the founder of Brilliant Exits and a divorce consulting support group. So thank you for everyone for being here. So again, thank the panelists, and I will just turn it over to Susan and just remind everyone as we go through this first part of the session that we will have a Q&A session towards the end. So thank you for being here.
I'm technologically challenged, I'll say that. Thank you, Ian, and thank you to AFSA for organizing this very important event. I am the Director of the Family Liaison Office, and we obviously work with families and employees. And unfortunately, one of the topics that we deal with all too often is that of divorce and separation. People often find their way to flow when they're in some type of family crisis, and this is certainly one of the areas we work with. We provide some confidential support to family members who are experiencing a separation or divorce, as well as to employees. I don't want to leave the employees out because we support both the employees and the family members. We provide information, resources, and referrals to other places that may be able to provide additional support to employees and family members on employee divorce. As part of the work of Flow, one of our employees, Diana, said, wow, did you know that there were a lot of other people in the department contacts that she had who all worked on little pieces of things that had to do with divorce. And wouldn't it be a great idea to get a working group together so all those people could meet together, pool their resources, network, and get to really know what the department had available to support employees and family members during divorce. So that happened in 2010, and the divorce working group has been meeting since then as a forum for the different shareholders to collaborate and network. The offices that work in, well, and organizations, but it's not merely offices, who work in the divorce working group are, of course, AFSA, our hosts today, HR Retirement, with Jacqueline there, HREX with Elizabeth, the work-life, I'm sorry, HRER, work-life, sorry, HREX, the legal office, medical office, transportation, DS, the Victims Resource Advocacy Program, FSI, and the AFSA. So there are a lot of different organizations and offices that come together to discuss the topic of divorce in the Foreign Service about 3 or 4 times a year. Since forming in 2010, the working group has produced a checklist for couples who are divorcing in post, has released a cable, the title is kind of strange, but it's a requirement to provide adequately for family members during separation and divorce. We usually shorten that to call it the Be Nice cable. And that's going to be released again very soon. It's in the final clearance process. We like to send it out about once a year just to remind everyone of their responsibilities during separation or divorce. We have updated the Divorce in the Foreign Service booklet, and it's available on the website on the internet. And developed a list called the Rights of Divorcing Spouses, which is something we always get asked, what are my rights as a divorcing spouse? So we've been trying to put together a checklist on that topic as well. So that's what the working group has been doing. This meeting today, I think, is a great opportunity to talk about some of the resources that are available and to put this out on the via the recording for everyone to be able to view. So the panelists we have today have already been introduced, but let me just first of all go and say once again that Daniel is a management counselor and is about to head to Tunis and is the management counselor. He has been born into a Foreign Service family, so he's been associated with the Foreign Service for a long time. I won't say how long. And he did serve as the state vice president of AFSA, and in that role I certainly enjoyed working with him as in my capacity as well. And I'm going to, after I do the introductions, I'm going to go ahead and turn over individually to each of the panelists to have a chance to talk and say a few words about the topic. So Daniel, over to you.
Oh, okay. Well, good afternoon. I actually have prepared some remarks. A few weeks ago, when I wore the hat of the state vice president of AFSA, it was my I have to turn this thing on. Sorry about that. Can you hear me now?
Okay, so very loud. A few weeks ago, when I wore the hat of State Vice President of AFSA, it was my annual duty to remind the department that in terms of family friendliness, the department consistently scored extremely low on a government-wide survey of all federal agencies. It scored very high on best agency to work for and near the bottom on family friendliness. As a management officer of some 30 years experience, and now in my role as a management officer, my first observation in today's forum is that the State Department is probably the most family friendly of all government agencies. For most federal agencies, family friendliness consists of providing the employee with more time to spend with their family, with teleworking opportunities, and some additional leave and maybe daycare. The State Department actually picks up an employee's family and moves that family with the employee to wherever it is that they're going to serve. It provides them with housing and medical care and schools, recreational facilities and employment where possible for family members. And it has entire offices, some of whom are represented here, Family Liaison Office, the Cloet Post, the Office of Overseas Schools, etc., whose sole function it is to address employees' families. And for most of us, we experience an overseas embassy community as our community and as our small town, all of which clouds an issue that becomes glaringly clear and usually comes as a surprise when a couple overseas considers divorce. In the most common scenario, the scenario that I will primarily focus on, where one partner in the marriage is an employee
and the other is not. The department has a legal relationship with the employee, and the other person is a person whose mere presence at post is basically provided as a benefit to the employee. Caring for the employee's family and providing us with the trappings of a community overseas is a business decision based on the comparative value of having one's family with one, and on the morale, productivity, and ability of the department to attract and retain talent on the one side, balanced against the cost and the possible negative effects of issues such as a messy divorce overseas. That might sound harsh and a bit oversimplistic, but it is important to understand the fact that it's important to understand that fact because many of the most common issues related to foreign service divorce overseas relate to the fact that one person in the divorce is an employee and the other is not. Other very serious issues arise when the divorcing couple, focusing on their own hurts, frustrations, angers, emotions in the moment, lose sight of the fact that in the business decision I just described, the department will always protect its own interests. Nearly all of the department's legal obligations are to its employees. And unless the court becomes involved and there's a court order, nearly none of its obligations are to the trailing spouse. That doesn't mean that they don't provide services, but the legal obligations are to and through the employee in most cases. That's a very important issue that affects things like housing, separation of household effects, shipping of household effects, and transportation of the non-employee spouse and family to his or her next destination. The reciprocal of that is also important, however. The employee spouse has certain obligations to their employer, and those do not change when a couple goes through divorce. Depending on the issues that lead to the separation or divorce, and depending on how those issues are handled by the couple, that can affect things like security clearances, medical clearances, and the continued ability of the employee spouse to continue working for the State Department or the U.S. government. Let me say this very clearly. It is very much in the interest of the employee that issues are resolved amicably and discreetly. This is much easier to do between assignments or in a stateside assignment than it is overseas. Obviously, if the couple is a tandem, both employees need to keep their employee obligations in mind. Even where only one spouse is a government employee, however, it is usually not in either party's interest to disrupt the employee's ability to earn a living. Last but not least is the important factor that the entire family is assigned overseas as diplomats representing the U.S. government. That means that in addition to the normal issues involved in any divorce, the special issues posed by the employer relationship, there are also U.S. government interests involved in making sure that the separation or divorce does not become scandalous, notorious, dangerous, or embarrassing, and that it does not hamper the overall efficiency of the department's mission overseas. Dirty laundry, such as extramarital affairs, substance abuse, domestic violence, unreported contacts, or dishonorable behavior, and Susan just mentioned the Be Nice cable, that's where this comes in. Dishonorable behavior such as failure to financially support one's spouse or family members can become fodder for disciplinary actions, security clearance revocations, and other penalties should they find their way into the public sphere. That can involve department officials as players in decisions that should be privately made by a couple, and can actually make the department's involvement a factor in a marriage that may or may not be salvageable. Robbing the couple of a certain amount of free will, imposing pressures that make it harder for a couple to reconcile, and potentially affecting careers. All of which argues, again, strongly for a couple to try to work their differences out privately, discreetly, and amicably, and if they decide to separate or divorce, to do so between overseas posts, or to curtail from post if they can't wait for the end of their tour. If the issues are so serious that the couple cannot wait, it would be wise to explore curtailing early. I'm told that MED will support any request for compassionate curtailment based on the expected dissolution of a marriage. AFSA can also advocate for employees seeking curtailments if desired, and I know that FLO does as well. If a couple is unsure whether they wish to separate or not, it may be worthwhile to consider a stateside assignment while they make up their minds. I am repeating, because it bears repeating and stressing, that separation overseas is a much more complicated matter. At post, there will be inevitably a loss of privacy and involvement of department entities. And if the event becomes scandalous, hampers operations, or if abuse is alleged, the couple may be involuntarily curtailed in any event. Voluntary curtailment is always preferable to involuntary curtailment. When a couple separates at post, the department has several responsibilities and objectives. It has to respect its obligations to its employee. It has to enforce U.S. laws and government regulations. It has to comply with court orders. And it has to do what it can to prevent the matter from becoming scandalous, affecting operations, or using an unreasonable amount of taxpayer resources. And ideally, it has to be compassionate. Towards that end, post management will try to ensure that all parties know their rights and obligations, and that they are informed about their options. And that they understand the consequences of certain actions, and to inform the employee that he or she is expected to behave honorably. Again, the Be Nice cable. That includes ensuring that both the employee and the spouse have and understand the information they need. Advising employees that they are expected to behave honorably, and to provide a means for the departing spouse or family members to sustain themselves. That might involve powers of attorney, arranging deposits in a stateside bank account, and other arrangements. The department may have to intervene as a family advocacy officer if there is any suspicion of violence or abuse. As part of its obligation to enforce U.S. laws, the department is required to follow up on any allegations of violence or child abuse, and the consequences can include termination and criminal prosecution. The separating couple, in turn, has a number of issues to consider. Travel, separation of household effects, issues related to disruptions in the education of their children, separation of finances, issues related to government benefits such as life insurance, health insurance, and ensuring entitlement to a portion of the employee's eventual pension. These can be complicated by a number of issues overseas. First, in the usual scenario of one spouse being an employee and the other not, the employee's spouse enjoys an unusual degree of control, since the employee's consent is required for almost any transaction unless a court order is involved. Second, the distances involved can create the impression that in separating, one spouse is abandoning the household, which can have implications for child custody and alimony unless addressed. Third, since information is usually channeled through the employee, a strong effort has to be made to ensure that the non-employee spouse has access to information, and if necessary, to a computer or other means of communication. Additional issues might include the possibility that the spouse is foreign-born, may never have resided in the U.S., and may have no other relatives or support structures in the U.S. They might have limited credit history, no work history, and may be unfamiliar with their rights in general. In some cases, the foreign-born leaving spouse may wish to reside in a third country overseas, further complicating the separation of household effects and aggravating the impression that the spouse may be abandoning their family. It is important that the leaving spouse be informed of sources of information, including Information Quest, which is administered by HR, and the Employee Consultation Service administered by MED. Both the CLO at Post and FLO in Washington are excellent sources of information. When a permanent marital separation or divorce is intended, advanced travel of the employee's spouse may be authorized to the employee's home leave or service separation address in the United States. Travel to a location other than the separation address would be on a cost-construct basis. Usually a separation agreement should exist. A separation agreement would outline in the broad terms of the separation. Note that the separation does not constitute abandonment, and might refer to powers of attorney or other issues. However, in the absence of such an agreement, the chief of mission may nonetheless determine that advance travel is warranted, and he or she may initiate travel on their own authority. The reasons for authorizing advance travel should be summarized in writing and retained in post records. Return travel of an employee's spouse may also be accomplished at the employee's expense, and the employee may be reimbursed later at the time that the employee is authorized a normal departure from post. Advance shipment of household effects may be authorized only if a legal property settlement exists or if the employee otherwise agrees in writing and identifies those items that the departing spouse may have access to. If HHE is shipped to a location other than the separation address, it should be done on a cost-construct basis. Let me just, I know I'm taking a lot of time, so let me actually just stop there. Or would you like me to go on?
It's up to you.
Well, I a few other things I'll say. Okay, so let me continue just to say that typically, if a couple separates at post, various forms of documentation should be considered. So one is a statement of mutual consent to be signed before advance travel orders are issued. And again, that should state that the separation is by mutual consent and that one party is not abandoning or deserting the other. Another would be an authorization to receive goods shipped from post, which would allow the departing spouse to receive HHE. A legal property settlement or list should be prepared by the employee, specifically saying what items the departing spouse should have access to and what items the spouse may remove from storage or post. A joint property statement would allow the spouse access to goods in storage. In other words, you could have a statement that simply says, property and I authorize my spouse to have access to it. Other conditions, both FLO and AFSA have lists of attorneys, and I would strongly recommend anybody considering divorce overseas to seek the advice of an attorney in the state in which they plan to divorce. As long as a couple has not yet divorced and the spouse is on the employee's travel orders, the spouse is entitled to hold a diplomatic passport. The separating spouse, however, is not eligible for SMA. A foreign-born spouse has the same rights as a U.S.-born spouse. And just to return to what I said earlier, if there is suspected abuse, or if by curtailing the couple is more likely to reach a settlement, in other words, if the couple is not playing nice, the post management can curtail the employee's assignment and simply decide to send everybody back to the United States. Last but not least, a Foreign Service employee cannot use an assignment abroad or a diplomatic status to avoid service of papers that may be involved. Sometimes it may be possible for a separating couple to reside, both of them at post. This can obviously occur when there's a tandem couple, but it could also occur if post has housing available that will not incur any additional costs to the U.S. government, such as the post owns empty apartments, as is the case, for example, in Germany, or may have houses on long-term lease that are vacant, as some posts do. In that situation, it might be envisaged that the couple separates at post usually in order to allow children to continue to end their school year at post. And typically that would be only until children end their school year at post, and then the couple would normally separate. So that does conclude my prepared remarks. Thank you.
Thank you, Daniel. Next, let's go to Elizabeth Royal. Elizabeth is a program analyst in the Work-Life Division of the Office of Employee Relations. And before I came to Flow, she and I were colleagues because I used to work in that office as well. She is the department's emergency visitation travel coordinator. She is the the program manager for the Information Quest referral service. Great resource if you don't know about it. And I'm sure Elizabeth will tell us. And also the wellness coordinator for human resources and a team lead on the HROCA crisis management support team. So Elizabeth is a very busy person, and we're really glad that you came to join us today. So.
Okay, can you hear me? To talk a little bit about Information Quest, on all of your chairs I have placed a brochure to give you a little bit of overview of the service. It's a great service for the entire department for anything that you possibly can think of, a question that you may have about any type of life event and so forth. This service is really for you, a free service to use. Typically, I like to equate it to Google. If you were to Google an attorney for a divorce attorney and everything under the sun would come up, this service will help you to narrow it down and really hone in on what you need for your particular situation. This brochure just gives a general overview on the entire IQ program and what you can use it for. But if I'll also turn you to the sheets about coping with divorce, specifically on how IQ can help with those situations. There is a sheet called Coping with Divorce, IQ, Information Quest can help. Tell you a little bit more about what this can do. It is a Information Quest 24/7 service. They help you with personalized matches to support groups, mediators, child care providers, and other resources to help you through this transition. Legal assistance, it includes free consultations with attorneys on up to 3 new legal topics per year. Free preparation of a simple living will, and discounts on preparation of other legal documents and fees, which of course the topic today on divorce, to include wills and other legal documents that you may need to change in that type of situation. They offer free financial assistance, including telephonic consultations to assist with credit and or debt investment planning, preparation of a family budget, and a $75 discount off additional fee-based financial services. And again, in a situation of divorce, a lot of these other types of things to think about in addition to the actual paperwork to prepare for a divorce, the dissolution of a marriage. There's articles and information on topics such as separation and divorce, mediation, coping, dividing your property, alimony, child support, and more. They also offer referrals for stress management, including fitness centers, exercise programs, anger management, and other wellness programs. One other thing I'd like to mention here is they offer free kits for all of these topics as well. So if you connect with the service, they'll send you a great kit with all kinds of free information and brochures and so forth. And then also the employee consultation service, IQ can connect you with Med ECS, or you can call the number that's directly listed on this brochure.
Thanks, Elizabeth. And I could point out that we do have someone from Med ECS. Helen Jones is here with us today, and so if there are any kind of questions that would go over into that area, I'm going to ask Helen to jump in at the appropriate moment. Let's move on to Sharon Savanti. Sharon went through a difficult divorce herself and became a certified life coach after that, and launched a variety of programs and services to empower individuals and couples going through a similar situation. She's been featured in the Washington Post magazine. She blogs at the Huffington Post and is the founder of an organization called Brilliant Exits. My husband saw the advertisement for this and said, "Oh, that's such a great name for a group that deals in divorce." So you have his thumbs up. Not that that counts for much. I don't expect so, but I can't imagine I will. But in any event, Sharon, we'd like you to tell us a little bit about the resources that you have that can be used by the Foreign Service community.
Thank you, and thank you all for having me here today. I really appreciate it. As you said, I went through a really difficult divorce. The one part in the Washington and less access to money. So I spent $60,000. So you can imagine the balance here, and you can imagine what was going on. And then after all of that expense, we got a court document, divorce document. Within a year, he stopped working. He was a surgeon, and he just stopped. So then I was faced with no support. And so I learned a lot of things going through the process. And I sat down and thought about what is it I wish that I had known when I was going through all of this. And that's how I came to create Brilliant Exits. And our flagship program, which is called Second Saturday, that happens, except for August, literally the second Saturday of every month. Most people don't know what to do when they're hit by divorce. They also don't even want to use the word a lot of times. So if you're helping someone going through that, first of all, it's going to take them a lot of courage to come into your office and say, this is what is happening. I know people, and I've heard of people who have divorced and been divorced for several years and haven't even told their coworkers and some extended family members, because there still is a stigma about it, which really is not quite fair, because divorce happens to good people. And also one of the issues with divorce is even really good, nice people can become ugly, not be nice when they're going through this. So a large part of what I try to do is teach people basically about the process, because it's a legal process that doesn't really take into account the emotional piece. And it is the emotional piece that causes a lot of the problems that require you to set kinds of rules that you've set. So with the monthly program I do, Second Saturday, which Diane has been to a couple of times. She's a great employee. She spends her Saturday mornings there checking it out. What I do is I bring in, it's a 4-hour seminar. I bring in, I'm always speaking and giving an overview, and I always have the same financial person, Debbie Marson, who doesn't sell a financial product and has been an expert witness in court for people going through separation and divorce in the financial aspect. She always speaks, and then I always have an attorney, but I rotate those attorneys, because one of the things I wished I had had was an opportunity for a second opinion. If I had questions I wasn't sure about, or that my attorney was handling correctly, or one of the biggest, most important things in divorce is choosing your attorney. So I do it this way so people can come in and they can hear different attorneys speak. The first time they come, prepaid, it's $65, and then they can come back as much as they want for only $35, and I do offer scholarships. And I bring in people like, just coming up just in September, I have, which is really, I feel so fortunate to have this, I'll have a legal panel, which is a judge who will talk to, he's retired now, and a judge and an attorney, often 2 attorneys, who will field questions and give their perspective. And a couple of things the judges said, and I don't want to go over time, but that are just invaluable, are things like, the system is not about punishing your spouse. What it is about is dividing everything. And you don't want to end up in court where I know nothing about your children, nothing about your family, and in a couple of hours, I'm going to decide the rest of your life. So when people come to you, I highly encourage you to educate them about the system and the fact they really don't want to head towards court, that they want to do the best they can in their circumstance to communicate with their spouse, and to decide how they're going to divide things up. The less they involve attorneys, and attorneys I've talked to who've been through divorce try not to use the legal system as much as they can, because they realize it costs a fortune. So the less the parties can use the legal system, the more they can divide things up on their own, the more money they're going to keep in their family's pocket. And that being said, there was a statistic out there that when divorcing, the couples, they each lose about 75% of their assets, which is just, I was astounded. But then I sat and thought, in Virginia and in many states, it's a 50-50 deal. You're dividing up the business aspect of your marriage. You get half, your spouse gets half. That other 25% for each of them was what they spent on the court system and attorneys. So it's really important for people, rather than run to an attorney as their first step, unless there's abuse or some other extenuating circumstances, the most important thing is for them to both get educated. And again, my program in September, and I do this 4 times a year, is co-ed. And we do get couples who come. We get couples who sit on opposite ends of the room, and then we get couples who sit next to one another and hold hands. So it runs the gamut. But now I've lost my train of thought here. It's an important program because my belief is if you educate both spouses on what the system is and what they have control over, what their options are, you're going to get a more, just a better divorce. And if there are children involved, you really want to make it as conflict-free as possible. Because the more conflict there is in the divorce, the harder it's going to be to co-parent. And what hurts the kids the most, and parents worry about this, it's not the divorce itself, it's their exposure to conflict and how their parents handle it. So if they have conflict while they stay together at post, that harms the kids. If they divorce, then the children have at least one home or both homes where they don't have conflict. They just have a better roadmap for life. It's much better for them. I want to just mention, in addition to this monthly program, I run, and this is free, what I call TLC, meetup group. And that's the 3rd Sunday of every month. And it's just a drop-in group, sort of like a peer group. And it's co-ed, and it's been great having it co-ed because the men give great advice to the women, and the women give great perspective to the men. And they listen to each other, whereas if I said the same thing, they might listen, they might not. So, and it also lets them know all men aren't bad and all women aren't bad. So that's open on a drop-in basis. Also, I do coaching, and what I call coaching/consulting. I had a lovely young couple from the State Department come and see me, and it was so sad. They were probably in their mid-20s. They had pretty much decided how to divide everything. They didn't have much to divide, and he was heading overseas, and she wasn't going to go with them. And they only had one bank account, and they hadn't totally divided that. So I said to them, you've done everything wonderfully. I don't understand why you're here, why you need my help. And they said, we're terrified. We don't want a divorce like our parents. The first time, the man said, the first time my parents talked was at my wedding 10 years after the divorce. And the woman had a similar thing, and no matter what I said to them, they were having a hard time grasping. You get to choose the style you want to divorce. And they were already doing it the way they wanted to do it. So it is one thing to pass on to the people you work with, that they do have a lot of choice over the process. And the more they understand it, the better off they'll be. Also, I wanted to mention, on my website, I have links to lots of really good free resources. These are by the American Bar Association. One of particular note for all of you is the ABA every year updates charts on divorce in all states in the United States, and how the divorce, the different rules, like grounds might be one way in one state, another way. Child support, custody, third-party visitation. It's a great resource because your people are, are coming back and going to different states. Also, there are checklists on things like living separately under the same roof, which may not be an issue here. There's also sample co-parenting forms where they can get an idea. What people don't know is what's involved. There's a sample property settlement, which they can download, and this is all free, and they can just get an idea what the process is about. Also, I wanted to mention on the co-parenting page, I have a kids and co-parenting. There's some resources for kids, but some really good resources are, there's a nonprofit called Up to Parents. It's great. It has, it's all free, and it has co-parenting information. It has exercises you can go through to help you. Their whole goal is to help parents communicate and do this in the best interest of their child. They also have a sister site called While We Heal, and that is geared towards people who aren't sure. they're separating, things aren't going well, they're not sure they're going to divorce, but they still have to deal with their kids and their families in a different situation. Again, that's free. And let me see, I also put some handouts in the back. One is sort of a 4-pager on all aspects of divorce. That is a good guide for you if you're helping somebody. And a brochure, and another flyer on a post I did for Huffington on, selecting an attorney. I mean, the nasty one or the nice one. So I am happy to help, and, be a resource in any way I can. It's a difficult thing to go through, but people can get through it, and they can have really good lives moving on. So I just grateful. Great State Department should be grateful. They have people learning about this and trying to understand how to make it as easy as possible. So thank you.
And thank you, Sharon. I know you've been a tremendous help to a lot of our State Department folks and really appreciate everything you've done for all of them. Last, but certainly not least, we have Jacqueline Lon, who is the Chief Policy Advisor in the Office of Retirement, and she has worked for the State Department for 26 years. And she's the primary point of contact for spouses seeking benefits under the various retirement systems, and I'm not too sure what they all are, but I'll let Jacqueline talk about it as the expert on the topic.
Okay. Good afternoon. The Department of State is the final adjudicator for all foreign service divorces. So employees who are, or annuitants, because we do it not only for employees active duty, but also for retirees, even employees who have separated and going to be eligible for a deferred retirement. So if they're covered by the Foreign Service Retirement and Disability System, the Foreign Service Retirement Disability Offset System, or the new system, which is called the Foreign Service Pension System, the Department of State is the sole authority in terms of adjudication for divorces in a foreign service. One thing that we ask all employees and annuitants to do if they find themselves in a divorce or about to go through a divorce, to let us know. A lot of times we look at these court orders and we see that there are default entitlements that might be paid to the former spouse. A lot of times with these divorce documents, we see what they call boilerplate type language, whereby it specifically says that each party waives their entitlement to IRAs, retirement benefits, things like that. Under the Foreign Service Act of 1980, Section 814 for the old system, FSRDS, or Section 861 for the new system, there's what they call default entitlements, meaning that if a former spouse was married to the employee during his credible service for at least 10 years, while there was have services credited in the computation of their annuity, they might be entitled to benefit. Out of that 10 years, only 5 years has to be while that employee was a member of the Foreign Service. Also, if the former spouse did not remarry prior to age 55, that former spouse could have an entitlement or eligible for a portion of that retiree's Foreign Service annuity. Now, those are the default requirements. A court order can always supersede the default requirements as we found in the Act. We do look for the court documents in those cases to specifically state what they want to give to the former spouse. If we see a court document that does not clearly satisfy our requirements, we ask that it goes back to the court or that the parties get together and come up with an agreement. We are not mediators in divorces for anyone, not for the former spouse or the employee or the annuitant. We do not tell the attorneys or their spouses, the retirees, how to construct divorce documents. Our role in the Office of Retirement is simply to review the documents and see whether or not it meets our standards to award any type of benefit to the former spouse. With having said that, the same information we provide to employees and retirees, we also provide as well. Any party can provide us with the divorce documents. Any party can contact us. We have information on our RNet webpage. I did leave a handout that gives a topical view of the Foreign Service Retirement Divorce process and how we do the adjudication that's in the back. But we also got a handbook on foreign service divorces. But the key information I'd like for anyone to know is that if you have a divorce, do not wait to retirement to inform us of it. When you do that and you're separated or have been divorced for several years or 10, 15 years, and that former spouse have an entitlement to benefit, we call the default right, they will get that benefit. Excuses like you haven't seen them for years and things like that will not nullify their entitlement. So if you have a divorce, let us know so that we can do determination letters to advise you and the former spouse of what those entitlements are, or provide you with options if you disagree with our determination as to what you can do to possibly correct that error. So the key thing for any type of foreign service divorce where there's a potential benefit is to first notify us. It's hard when you see retirees at retirement, we're doing a final adjudication, we find out that their former spouse, that they have been divorced for over 15 years, might have an entitlement to that benefit. They will be awarded that benefit unless we disqualify them for other reasons. Okay, that's all.
Thank you, Jacqueline. I think we're ready to take questions now. So if there are any questions from the floor? Yes.
A question about what you just said about entitlements to pension plans. If your spouse has stated their intention not to partake in your pension system because they have their own financial resources, is there a way that that can be, does it need to be in the document? Is there a special form? Is there any way that they can document that so that it's legally acceptable for your office?
What's required for that is that former spouses has to understand that the right that they're waiving. And so language in a divorce document that says that the former spouse or the defendant or whatever they are in the court document, it has to say that they're expressly waiving their benefit under the Foreign Service Retirement and Disability System or the Foreign Service Pension System. And if they're waiving their benefit, be specific. If it's the survivor benefit they're waiving or the pension benefit. If we see an order that says that the former spouse is waiving their entitlement to a survivor benefit, when we read that, we're going to award that former spouse, if they're entitled to it, a pension benefit. The pension benefit is what the former spouse receives while the employee's alive. Okay, so for orders like that, and if there is an intention to do a waiver, it has to specifically refer to that retirement system. General language will not be accepted.
But there's no specific form or anything like that?
No, there's no specific form. In our handbook, we do give some type of wording that you can use, but there's no specific form. We can review draft documents for you and see whether or not it's acceptable or recommend certain type of language, but it's really up to you to construct the divorce documents.
Thank you.
Okay, other questions? Yes.
First of all, I'd like to thank Sharon. I've actually been to her seminars on 6 different Saturdays over several years. And my husband actually went as well, and she's actually very humble, very modest. These are the best thing going. They're fabulous, the co-ed ones as well as the ones where it's the women involved. My question is actually for Jacqueline again. I understand that if you've been in the Foreign Service for less than 10 years, that there is no right to that benefit. But are you saying that you should nevertheless have something written in your divorce?
If you've been married for less than 10 years?
No, we've been married for 33, but it's second career for both of us. We're a tandem. So for each of us, it's far less than 10 years.
There's no default requirement, meaning that the Act, Section 814, 861, will automatically award you a benefit. So if you have less than 10 years of credible service, when we compute your annuity, then there's no default entitlement. But your court documents can override that. The court documents take precedence over the retirement law. Okay? So even though you may not be married for 10 years, if it's silent, you or your husband will not get any benefit. However, if you have a court document that says that they're going to get that benefit regardless of the time of marriage, then that is what we're going to honor when we adjudicate the case.
But you don't have to put language in it.
If you're married for less than 10 years, you do not have to put language in it because it's not meeting that default requirement. But if you are married for at least 10 years, you should put some type of language into it.
All right, thank you.
Other questions? Yes.
Have you ever seen an instance where in an amicable divorce with young children still, the ex-spouse is allowed to stay on the orders and go back overseas to keep the family together, or at least close.
To go back overseas?
I don't think there'd be a scenario where someone who is divorced would remain on orders,
orders.
because on orders, there's a, you fill out the OF 126, which lists people who are legally dependent upon you, and that would be a spouse or a same-sex domestic partner now, or a child, and I think you have to be on the OF 126 in order to be on orders. And being on the OF 126, you're on it because you're a spouse, not because you're a divorced spouse. So I suppose there would be no way that someone could go as a member of household, perhaps.
That's what I was
But,
thinking.
I don't think you would be on
Right.
orders, given the divorce scenario. And I think that if anyone, a member of household is someone who accompanies the employee at their own expense and who is declared to the post as someone who is living in their residence and declared as a member of household. So I would see no bar for declaring a divorced spouse as a member of household, but they would not be on orders, and it would be at the employee's expense in terms of travel. And would be the other benefits that would accrue to an eligible family member would not accrue to a member of household, such as access to the medical unit, access to a post-commissary, evacuation benefits, mail and pouch. Anything else? Am I covering it?
You're good.
Shocking. Visa issues, yeah, but I mean, would be no bar to having somebody as a member of household. Okay. Other questions? Yes, in fact.
This one's related somewhat to custody. If you've had a divorce and you were overseas and now you're back and you have the ex-spouse who isn't comfortable anymore with the child going overseas, it's a disruption for the foreign service employee because now they are bound to stay in the U.S. How long can they allow that to happen? Because it's almost like you're being held hostage by this person's ability to say, well, I no longer want my child to go overseas and I won't be supportive of co-signing for a diplomatic passport or something like that.
Anybody want to take that one? I can tell you, I'd be very hesitant to answer that.
This is a very
Common scenario, actually, and it affects a lot of people. About a year or less than a year ago, there was also a case that we were asked to participate in, AFSA was asked to participate in, related to a spouse that was alleging that it was dangerous to take a child overseas and seeking a court order to prevent, related to custody, to prevent the other spouse from having custody because their career took them overseas, which we consider to be a very important issue that affected the entire Foreign Service, obviously. But the short answer is that there is not a lot one can do. In most states, there is an age of I think it's called an age of consent. In Maryland, I think it's 16 years old, when a child can basically voice their own free will as to which parent they wish to reside with, or both. And I think most states have such an age, and the answer to your question is probably until the children reach that age. Otherwise, short of getting a court order to the contrary, there's not much one can do. And courts do appear reluctant they tend to have the view that most places that are not the United States are not as good for the child as the United States.
And I'll piggyback that, saying in Virginia, attorneys have said, who speak, that judges believe Virginia's a great state. Why do you need to take your kids elsewhere? So even if you're not going overseas, you can get stuck in the state. And with custody, it's always modifiable. It's something you can always go in and change because children change as they develop.
Yes.
A question related to that about the Foreign Service requirements, which is the 5-year rule. Are there any exceptions to the 5-year rule related to custody? where but you still be required, or you'd have to figure out what to do with your career as well.
Yeah, I mean, the 5-year rule is written in, well, it's actually an 8-year rule, but the 5-8 rule is written into the Foreign Service Act. And it is possible to get waivers, a limited number of waivers to the rule. And limited numbers of waivers are granted sometimes in this sort of situation, but it's not unlimited. So one could get a year or two of waiver quite conceivably, but not indefinitely.
The question, if a Foreign Service officer retires and the spouse is getting their share of the retirement benefit, if the Foreign Service officer goes back into the U.S. government and the retirement benefit is canceled for that moment or put on hold, what happens with the spouse's share?
If the former spouse was awarded a benefit, it continues. What happens?
Does it continue from the government?
The question is if the former, you have a retiree from the Foreign Service, gets reemployed back into the government. It continues for that former spouse. Now the payment for that is going to be deducted from the employee's salary of that reemployed annuitant.
That's a big shock.
So there's no interruption in the divorce payments or the pension payment. Now, you could have a divorce document that says something different. But if it's based upon the general language and in the Foreign Service Act, that former spouse pension payment will continue even though that retiree is now a reemployed annuitant.
And not get this for her back.
Right, we're just going to deduct it from the employment salary. But we still want to pay you from the Foreign Service Retirement Fund.
A lot of people don't know that. Okay, thank you.
Okay.
Are there other questions? Sharon did mention these sort of emotional aspects to divorce, and I think it might be a good chance to ask if our representative from ECS, Helen Jones, would like to just have a few words about how ECS might be able to assist under those circumstances. Why don't you grab that? Turn this on.
Thank you. ECS, there are 6 of us that are licensed clinical social workers. We practice independently, and so we can provide counseling services. Like I have couples that I work with as they're going through the divorce, working with issues about custody and dividing properties and things like that, and helping them to deal with that in hopefully a healthier way. We work with couples as they're determining this marriage be saved. So we can provide some counseling services to couples and to employees as well. We are currently located in Columbia Plaza, SA1, or over in Main State, and our services are confidential. We don't. People get concerned if they come see us that Ned will know about it, and that's not the case. There's a wall between us of confidentiality. We also do work with the family advocacy cases, so if there were a domestic violence issue or something, we would be involved as well to help families negotiate that path. And also if there is a need to ask for curtailment or a 5-8 waiver extension, we also give input on those issues as well. You would contact us and let us know your situation, and we'll kind of tell you how that system works and how we can help you with that. Yes.
Will you mention your support group? That's so wonderful.
Thank you. It's in my mind. Ellen Milner, our lead social worker, facilitates the divorce support group, and that means once a month. I've left a list back in the back, the bright green sheet of paper that has the other support groups that we also offer for grief and cancer support group and elder care as well. But we do have the divorce support group specifically, and Ellen would be glad to help you out. A couple of people just come and talk about resources they found or issues that they're going through, and they're very supportive of each other, so it's a very good group to know about. Thank you.
Thanks, Helen. Do we have any additional questions? No? Then I guess I'll close the session, and thank you all for coming. And be on the lookout for the next cable coming out to provide the information on supporting families. family members during a separation or divorce. Thank you all.